about spies that links the reference to commission in the tweet?
Not my lady, not my lady.
So what does it refer to?
The plan, my lady, if I make this point, the plan in the commission, which Mr. Zuma refers, has many facets. But essentially what he says is the plan is to remove him politically from the ANC or power. It is to character assassinate him, and unfortunately he also referred to assassinations physically. But that's the context, that's the connection.
So now, removing him doesn't mean necessarily any connection to spies?
No, not at all, my lady, that's our submission, not at all.
But do you agree that the mention of the word commission in the tweet is open to many interpretations?
My lady, I think what we need to concern ourselves and in this context is what a reasonable reader will have, will understand.
Yeah.
That essentially is the term. Now, what I was setting out was the context and the connection. Earlier I would have said, my lady, that if a reasonable person cannot make such a connection. Now, the reason I say that, my lady, I'd like to point you to what we should see a reasonable person as. My lady, I refer you to page 19 of our heads. Well, let's start at page 14, my lady. That's paragraph 42. And this is where we make our major point, because essentially what this case turns on, and I think both parties appreciate this, is whether a reasonable reader will necessarily imply that or understand that Mr. Hanekom is an apartheid spy. My lady, in the case of Channing versus the South African Financial Gazette Limited and others, the court had held as follows. The citation is there, my lady, and I'm going to read the underlined portion, or maybe the last two sentences. It says, from these and other authorities, it emerges that the ordinary reader is a reasonable, right-thinking person of average education, normal intelligence. That's the first thing. And then the second, the court says, who is not a reasonable person, a reasonable reader? He is not a man of morbid or suspicious mind, nor is he supercritical or abnormally sensitive. And he must be assumed to have read the articles that was in the context of newspaper articles that an ordinary person would read.
Yes, okay. My recollection, and I'm reminded by a rereading of my judgment, that there was no dispute, and you just confirmed that both you and Steinberg are at Eden on the same page about the concept of a reasonable person. So there's no dispute about the legal principles that apply to who qualifies as a reasonable person. And you started out the main case on the previous occasion very helpfully, telling me no dispute about legal principles on the law of defamation.
Correct.
Correct. Then you also confirmed that there's no dispute on the question of facts. Correct? Yes? And then my only task was an interpretive one. Correct? You can be reminded by the many television recordings of what was said, how it was said, and the
Correct.
tone in which it was said,
Correct.
even if you don't have a transcript.
Correct.
Yes?
Correct.
Oh no. There was agreement about the facts, correct? Yes.
Well, yeah, I think the factual.
And there was agreement about what I needed to do.
Correct.
And what I needed to do, both of you told me, was an interpretive exercise, correct?
Okay.
Okay, so I'm happy that we had made that progress then, and we're making that progress now. Coming back to the question of the connection. So we agree that who a reasonable person is.
Correct.
My difficulty or my inquiry with you is this. When there's a reference to the commission in the tweets,
Yes.
now Mr. Zuma's evidence, if I recall, went on for almost an entire day, perhaps even longer, you'll remind me, but he said many things.
Correct.
That we agree on.
Correct.
Now, of the many things, which, say he said 20 facts
Correct.
or themes that he covered in his evidence,
Correct.
which of the 20 themes would a reasonable person attach to that tweet? That's my question.
Okay. My lady, that question may well have two answers. In our submission, a reasonable person who reads the entire transcript, let's say the transcript, or at least for the 2 days, the theme which Mr. Zuma talks of.
So a reasonable person must read the transcript first.
Yes, that's the case. That's
Well,
our
this is
submission.
a tweet we're talking about. We're talking about a person who reads the tweet, not the tweeters that we don't regard them as necessarily reasonable people, but we talk about the concept of a reasonable person as a legal construct. That's what we agree. So, are you saying a reasonable person is one who has to read the transcript to come to that conclusion?
We
How
submit
do you work that out? People are reading tweets. Are you saying they must go and read the transcript?
Well, the authorities, that's what they say, my lady. The authorities that I just referred you to says exactly that. That's the case of Channing. It does say, obviously the context is important. This was in the case of an article, a newspaper article. And the court says a reasonable reader will then go to the, how can I put it, the basis, so to speak.
Where does it say then?
At the underlined part.
The
Says-
underlined part is not a man of morbid suspicions, nor is he supercritical or abnormally sensitive. He must be assumed to have read the articles as the articles in the newspapers are usually read.
Correct.
Now, he's talking about a newspaper article. You're talking, well, this case is concerned with a tweet.
Correct.
It's not concerned with a transcript.
Correct.
So, I mean, you can't expect the ordinary reader of tweets to run off to a transcript which might not even be ready and available.
Well, my lady, I'm not sure whether, well, let's start here. If my lady's proposition is this, that irrespective of the reference, so I may refer you to a book, for example, a book about Derek Hanekom, and refer to it and say, I would expect a reasonable, and the court does, expect a reasonable person to go read that book to understand. That what you term is a reasonable person or a tweeter is lazy, is another question altogether. There, of course, it's like newspaper articles. Some people just read the headline and form their view. And they talk as if they have read the article. And some of them actually read what the article says. And that's what a reasonable person or a reasonable reader, at least according to the courts, is expected to do. I do not think that would be an unreasonable expectation. Unless it may be that, my lady, there's another authority that says it's fine to look at the headline. I'm not aware of that authority.
No, I agree with you entirely that if you want to form an opinion and if you want to pursue a defamation claim, you can't just base it on the reading of a headline. But we're not dealing with headlines. We're dealing with very cryptic comments and tweets, a very different medium, which forms public opinion. We agree with that, do we?
My lady, I would submit not reasonable. Now let me just go back to this. Just make a comparison as an example. My lady is talking about a newspaper article.
No, you are talking about a newspaper.
Well, that's the case. That's the authority. If you look at it in proportion, it would similarly apply to a book, for example. But the court expects a reasonable reader to. And my lady, it doesn't say a reader. It says a reasonable reader. Is to go and say, I've seen this article that says so-and-so is corrupt, so-and-so is biased. I must go into what the actual article says, or actual book, because otherwise a reasonable would be misguided by the prejudged or views of the public.
I understand your argument. And in this case, it's not necessarily the transcript, but it might be the television broadcast of Mr. Zuma's evidence.
Well, my lady, the reference is we're talking about the transcript.
No, the tweet is talking about reference to the commission. I mentioned transcript by way of example, but it's accessible.
In the transcript.
It's accessible in the transcript, but it's also accessible through other media, correct?
Correct. But my lady, unless what my lady is suggesting is that, well, it's enough to look at the snippets of whatever view of for example, a certain show can play snippets of Mr. Zuma's testimony.
No, I'm not suggesting anything. I'm just trying to understand, and let's go back to my initial question.
Correct.
My question is, what would a reasonable person reading the tweet make of the reference to commission in the tweet? That's my starting position, and I understand you to be saying that the reference to the commission means that the person a reasonable person forming any opinion on the tweet would have to have regard to what was said in the commission.
Correct, entirely.
Whether that information of what was said in the commission is in a transcript or in some other form of media, wherever that may come from.
No, my lady, I would differ in the last part.
Are you confining yourself only to a transcript then?
My lady, the case, I think what we're dealing with is what Mr. Zuma testified about at the commission.
Yes.
My lady, if I may just make that point.
Just on that, what he testified about at the commission is contained in a transcript, but it is also contained in other public platforms. Is that correct?
I accept it.
And I agree, I understand what you're saying, that to form an opinion on snippets is not what you're saying a reasonable person should do.
Correct.
But if there is a whole transcript, if there's a whole publication and accessible publicly of what proceeded in the commission, then a reasonable person should form an opinion based on what actually and completely happened at the commission, however that information is made available to the reasonable person.
My lady, that is if I highlight full portion, so that you don't...
Yes, I understand that.
No, I'm just saying for the record, yeah. As long as we understand that's the case, I think that's our submission.
Right. And such a person, having regard to the full information of what happened in the commission, will form the opinion what? My question still stands. What opinion will they form of the connection?
Exactly what Mr. Zuma said, that Hanekom was an enemy agent.
That Hanekom was an enemy agent?
Yes.
Yes.
That's the submission. But the point is...
that is exactly the inference that Mr. Hanekom says a reasonable reader would form. So there's no dispute between you. as I understand, or am I getting the wrong end of the stick here? You're both saying the same thing.
My lady, I wouldn't necessarily say you're getting it wrong. But what I would suggest, my lady, is, or what I would submit, my lady, is that Hanekom selects an interpretation that says Mr. Zuma referred to him as an apartheid spy. That's where Mr. Zuma and Mr. Hanekom part ways. Or I would submit Mr. Hanekom part ways with a reasonable reader.
But let's take a step back. You're saying that a reasonable reader will form the opinion on reading the tweet that the reference to the commission in the tweet means a reference to known enemy agent. That is what Mr. Zuma says would be the inference.
Yes.
And I'm saying
yes.
that my understanding is also, and the Steinberg will tell me if I got this end of the stick wrong, that Mr. Hanekom also says that what he understands and what a reasonable person understands from the reference to the commission is exactly that. That it's a reference to Mr. Hanekom being a known enemy agent. And that brings us to the fundamental question you asked me to interpret. What is the meaning of known enemy agent?
Correct.
That's where we are. And that's the point of departure. Does it mean apartheid era spy, or does it mean something else? That's the crux of the case. It's always been so.
I'm indebted to the court. My lady, I don't want us to lose the context, and I'm not suggesting that you are. The link necessarily is about removing Zuma from political office. That's where the plan is. Mm-hmm. Now, we then go to the meaning or sting, as they call it, of what a known enemy agent is. We then say, let's take a step back. Assume that we are ad idem about that. Our question is, would a reasonable reader understand this thing to be so? That's where, for me, it is. Now, and that's where we differ, my lady. My lady, what I've been submitting earlier is that when you look at what the reasonable reader is, or should have regard to, he wouldn't make a deduction that Mr. Hanekom is an apartheid spy. Now, my lady, it then goes to what a known or enemy agent is. Okay. I beg your indulgence, my lady. I just want to look at the correct reference in the head. Now, my lady, an enemy agent is where there is some confusion. Mr. Hanekom says that necessarily means an apartheid spy. We differ, or Mr. Zuma differs. But, and the court in its judgment says, well, historically, enemy agent has always referred to apartheid spy. My lady, I'm not certain that we can use that as a starting point. I'll tell you why, my lady. My lady, in the apartheid era, for example, as an example, there were people who regarded others as impimpi, right? In various contexts, be it strikes action and all of this. People do call each other impi or amakunda. Now that doesn't mean that person that must make a link to the apartheid era context. It will be in that particular context.
What would that context be that's different from apartheid era context?
It could be for organizational. So, for example, in trade union issues, there may be disputes about basic salaries and all of this, and someone may decide not to participate, or may decide to talk to management to tell them. But that link to apartheid cannot be made.
Well, I agree with you that there may be various, let me accept for the sake of your argument, that impimpi can refer to many contexts in which somebody sells out, so to speak, and who you sell out to might be the apartheid government or any other sources. But the thing is, it is one, apartheid spy is one of several connections. We're not talking in the context of trade unions. We're not talking in the context of any other thing but the politics of South Africa, the ANC, and the former South African government. Correct?
No, my lady. Might I just clarify you? This is where we differ. This is when we then still go to the historical connection which we suggest should not be there. We're saying in the context of what Hanekom does or did for the removal of Mr. Zuma from office, that's where the enemy agent or the context enemy agent is used. So the connection that the court may want to make or Hanekom may want to make is unjustified. That's our submission.
So I understand what you're saying, that he sold out on Mr. Zuma or the ANC. Is that what you're saying? That's why the reference
in this context, correct.
No, I accept that may also be an interpretation, but it is one of so far three options. One, selling out on the ANC to the apartheid government. Two, selling out of Mr. Zuma to opposition parties. And three, the possible context, but not particularly relevant in this instance. Three, selling out as in a trade union context, and there may be other. But it basically means selling out. You're saying a known enemy agent in the context means selling out, not necessarily apartheid era agent, sort of selling out. I understand.
I mean, that's a two minute. My lady, it's important that we have a debate because, and I'm not suggesting that you are not unaware of the test, but we submit that overall that debate does have some plausible grounds or can be entertained for a further determination by the appeal. That's what we submit. We cannot convince you further, and it is probably impossible. It would be expecting too much of the court.
Sorry, what can't you convince me of?
No, I'm saying there's a finding that you've made about the connection. What I'm suggesting is that what the debate or our submission point that there is reasonable prospect that another court would interpret what you interpreted differently.
And they would come to the interpretation that you suggest, and that is that it was a selling out of the ANC or Mr. Zuma.
Correct.
Okay, now I get that.
My lady, I'm not certain whether we still need to traverse the argument of what an enemy agent is in light of what you said.
That is the central question of what it means. So I don't know what further submissions you want to make on that.
Well, my lady, can I just consult this? Thanks, my lady. My lady, then I would move to, well, the submission would be that in those circumstances, the statement would not be defamatory. And would submit that as I've submitted just now, that then another court will probably come to a different, will come to a different conclusion. My lady, the next main issue really is what the court suggests, but again it's dependent on the debate we just had about Mr. Zuma propagating a false narrative against Mr. Hanekom. My lady, that only is relevant if we assume that Mr. Zuma meant, or a reasonable person, or reasonable reader rather, would say Hanekom is an apartheid spy. So that debate gets sorted out in that column, if I were to say it like that. And I wouldn't like to traverse on it too much. I leave the next major point is...
Sorry, that is was my understanding when the main case began, that I need make no findings of facts as to the truth of whether he is or he is not a spy. That's what I understood the proceedings to be, and it remains correct. Correct me if I'm wrong. Well, that some other forum is going to be debating who is a spy and who isn't a spy, and particularly whether Mr. Hanekom is or isn't a spy. Okay. Is that so? Your understanding and mine? It is my understanding.
Okay, my lady, it's the manner that the judgment makes certain findings, and I'm not going to criticize the court on those findings, but there is a factual finding in the judgment that Mr. Zuma, and that's at paragraph 75 and 80 of the judgment, that Mr. Zuma is propagating a false narrative. But I say that depends on the finding, whether people would understand that Hanekom is an apartheid agent or not. I wouldn't want to debate that further at this point.
It is a ground of appeal, isn't it?
It is, my lady, it is.
And if you're still standing by it, I'm going to have to come back to it.
My lady. My lady, I would like to then go to the inquiry in relation or the ground about freedom of expression and context. My lady, in the head that appears from page 23. My lady, I don't think we can have much debate that Mr. Zuma, like everyone else, enjoys the right to freedom of expression, and that extends to political expression, political free speech. So does Mr. Hanekom. And they both enjoy that right equally. And it then goes back to where the limitations may well occur. Section 16.2 of the Constitution then gives us the express grounds. But further, there's a ground that limits the right on the basis of infringement of dignity, amongst other rights. But where we are is the dignity point. What we submit, my lady, is that in that discussion or that balance, we must accept that we must move from the premise that both Mr. Hanekom and Mr. Zuma enjoy the same dignity as well. Not that Mr. Hanekom has more dignity than Mr. Zuma. They both enjoy, and they both have to be accorded similar right or similar standing. Now, my lady, our ground of appeal is that effectively what Mr. Hanekom seeks and what the court finds is an unjustified limitation of Mr. Zuma's right to freedom of expression. And I say so in this context, my lady. My lady, it is accepted that when you balance the dignity and freedom of expression, one has to look at the context once more. My lady, I refer to numerous cases that deal with political debate and all of this. But the point there is, where it's in a political space, a political debate, the courts normally give more leeway to the discussion. So in other words, it goes back to the first point, that those people that are engaged in such a political debate, I expected, and the court say, well, it's a good thing in our democracy. They usually insult each other, call each other corrupt, as we name them any other word. But that's the robustness of the debate. And the importance of this debate is exactly to take us away from the past where people would be controlled what they can say politically. And submit, my lady, what the order then does, or what Mr. Hanekom is asking the court to do, or has asked the court to do, is to say, well, Mr. Zuma should not enter into political debate.
We don't say that.
At least in relation to mention, well, the order says, well, in relation to naming Mr. Hanekom or implying that he was an apartheid spy.
No, court order cannot imply. Court order has to be very specific. Where in the judgment or in the order do I say that Mr. Zuma may not enter into debate, political debate?
No, my lady, that's not my submission. And I apologize if that's the...
Well, I'm using your own words, and I'm raising it now so that there's no misunderstanding between us as to what you mean.
Okay. My lady, what I'm submitting is that effectively what the court order says, and I'll read you the order. It says, the respondent is interdicted, that's order 5, is interdicted from publishing any statement that says or implies that the applicant is or was an enemy agent or an apartheid spy, for example.
Where does it stop Mr. Zuma from participating in public debate?
Well, I'm coming to that, my lady. Now, what we are suggesting that in any political debate or free speech, people use all sorts of language towards each other. Now, Mr. Zuma is then gagged with not saying anything that implies that Mr. Hanekom was an apartheid agent or was an enemy agent. For one reason,
Make up your mind. You're saying that I have gagged Mr. Zuma from saying anything that or gagged him from saying that he's an apartheid spy and that he's an enemy agent. That's what you're saying.
That's what it says.
But you're also saying that enemy agent, non-enemy agent, doesn't equal apartheid spy.
Yes, my lady.
Right.
Now, my lady, may I just go to the main submissions I was making?
Are you leaving this because I have some few questions?
My lady, let me take the question.
Okay. So we only get to the section 16 of the Constitution, freedom of expression and the proportionality test and the dignity provisions and so on. If we get past the interpretive question, if I have found
Yes.
that known enemy agent was not defamatory,
Correct.
Mr. Zuma could have shouted that from the rooftops. Nobody would have stopped it. Dignity, Section 16 and all of that doesn't come into play. First hurdle is to persuade me and any other court, I think, that known enemy agent does not mean that he's an apartheid era spy, because it was also common cause, Mr. Stefan, that if I find that it means apartheid era spy, it is accepted between both counsel, both sides, that that would be defamatory. Your case has always been that it did not mean apartheid era spy.
Correct.
I got that right, have I? Good. So it gets back to the interpretive question. There was no dispute between both parties about the constitutional provision.
Correct.
Everybody accepts, and definitely I'm not about to put any restraints on robust debate. That's not what I'm busy with here. Mine is a very simple task, and that is to place an interpretation on the tweet.
Yes, my lady, the submission we're making is that this is in a context where we submit that the court erred. Now, what we are suggesting is that what the court order does effectively, as it stands, and that point is addressed in the ends. What it does is, it is certainly a forward-looking order that he shouldn't say anything of the sort, even if it's not defamatory in any context. For example, my lady, I may refer you to
Where
the
did
case.
you get that?
Well, my lady, you've just made that point. You're saying that if it is found, or as you have found, that it is defamatory.
If it is defamatory, then he can't make any defamatory. He and nobody can make any defamatory statement.
My lady, may I just finish up the point? If you have come with a particular context, particular set of facts, evidence, and all of this, and in that context, in this case, you have made an inference or interpretation or finding that in this context, Mr. Zuma or the statement meant that Mr. Hanekom was an apartheid spy. Now, practically, it may well happen that in another context, Zuma may actually say Hanekom was an apartheid spy and provide evidence. Now,
I would have no difficulty with that, and that's exactly what I encourage him to do by making it clear in my order
well,
that he's free, that my judgment has no impediment to him putting up the evidence in whatever platform, and particularly defamation.
well, my lady, that's different. The order says the respondent is interdicted from publishing any statement that says or implies that the applicant is or was an enemy agent or an apartheid spy. What I'm submitting, my lady, you may disagree with it. That's fine. What I'm submitting, my lady, is that, in fact, it cannot be applicable in all other contexts, because there may well be other grounds in those various contexts that justify making of that statement.
I agree with you entirely.
I'm glad, my lady. My lady, might I refer to the case of RM versus RP, which is which I rely on for the proposition I'm making. It's at paragraph 100 of our heads.
Paragraph what?
100. 100, my lady. My lady, I then moved to the order which you qualified the previous order with. My lady, the order number 6 says, the interdict in the preceding paragraph does not bar the respondent from testifying truthfully as he is required to at the Judicial Commission of Inquiry into allegations of state capture, corruption, and fraud in the public sector, including the organs of state. Now, my lady, my point is that that is specific to a particular commission, which in effect, it means that Mr. Zuma is going there already with a contempt order hanging on his head, effectively. So if he goes there and says, well, Mr. Hanekom was an apartheid spy, Mr. Hanekom would be entitled to come here and say, well, there he goes again. My lady, there we...
Are you seriously making that submission?
You may not agree with it, my lady.
No.
But we're making it.
What don't you understand about what I say in that order? About truthfully, and you don't make statements without backing them up. That commission is taking evidence. Show me one single fact that qualifies as evidence that Mr. Zuma led in this application that suggests that Mr. Hanekom is a spy. Has he led any evidence here?
Well, my lady, I'm glad you say that. My lady, that was not the case that was brought before you, at least by Mr. Zuma.
Exactly. So no evidence was led here.
My lady, it's because it's for a particular reason. Because Mr. Zuma's defense was that he didn't refer to Mr. Hanekom as a spy. And as you correctly point out, the question is not factual, as you correctly pointed out. The question is at the stage of interpreting what a reasonable reader would do.
Yes.
But if we are to go back to evidence, then it would be asking Mr. Zuma to prove a case that he was not making.
Let's backtrack again,
Okay.
Mr. Stepan, because both parties came to the court on the understanding, which you narrowed down for my convenience and your own convenience, in the context because the commission was still proceeding and it was common cause from both party submissions that neither party thought it necessary to refer to oral evidence, neither party needed to go down the road of proving the fact or otherwise as to whether Mr. Hanekom was an apartheid hero spy. And I understand that you're saying that I made that a finding that Mr. Zuma's statements were false. That is what you're tackling. Is my understanding correct? That I should not have made the finding that Mr. Zuma's statements were false. Is that what you're saying?
Correct.
Okay.
My lady, remember we dealt with the point of a false narrative. And I said that also rested. And I'm glad that we don't dwell on the facts or evidence. Because had we done so, maybe we would have gotten somewhere. But that's not the point right now. The point we're making is the practicality or what it means for Mr. Zuma's freedom of expression going forward. And our case is simple, Melody, at this stage. Of course, we will accept that you don't agree with it. Hence, you make the order you make. But that's not the test you need to apply here.
What is that test?
Well, the test for leave to appeal, Melody.
Oh.
My lady,
And you're saying, applying that test, another court is going to say that this is a gagging order on Mr. Zuma at the commission.
Well, not only the commission, in all
or
other
any other
platforms.
platform,
Correct.
that he can't call Mr. Hanekom an apartheid era spy
Yes. Or enemy agent.
unless he puts up the evidence.
Or enemy, no.
So you can't call, are you saying that Mr. Zuma can't call Mr. Hanekom a spy even if he doesn't put up the evidence?
Well, yes,
Yes,
he can.
he can.
But
he cannot say that
he didn't do so yet.
in this case.
Yeah, he didn't do so.
Let me understand that very clearly. Will you just repeat that for me?
Yeah.
Mr. Zuma can?
All right, let's not engage it that way. Mr. Zuma, in another forum, in another context, may say, well, Mr. Hanekom is an apartheid spy. Or will then say or maintain that, look, Mr. Hanekom is an enemy agent. Never mind the context at the time. But if let's say enemy agent, let's take what we're dealing with. If it says in another debate with his friends or something, Mr. Hanekom is an enemy agent and obviously he doesn't provide evidence.
Doesn't provide evidence.
Yes.
Yeah.
And he makes an argument why he says so. But what I don't understand is why a court order would limit that. If anyone has a problem, if Mr. Hanekom has a problem with that, in that context, he's not prevented from coming to this court.
Again.
Yes.
And debate the same thing.
Not prevented at all.
Just find me some, or show me some authority where it says, well, I'm having some difficulty with this because your team agrees with the other side that if non-enemy agents equals apartheid era spy, I know you take it differently. If then to call someone or refer to someone as an apartheid era spy has a defamatory, no debate about that. That is still your position, correct?
I think the point was made yesterday.
Yes?
Yes.
Yes. That is your position.
Yes.
Now you're telling me that Mr. Zuma is free to say in any platform that Mr. Hanekom is an apartheid era spy. Mm-hmm. Is that what you're saying to me?
Indeed.
That it's not defamatory.
My lady, what I'm submitting is this.
I think a straight yes or no will clarify my mind.
My lady, it becomes a difficulty because I need to illustrate.
Well, as lawyers, you know, it's black or white.
Not always. My
yes
lady.
or no.
Not always, my lady. The point is the context of the case that was before you had a particular set of facts, occurred within a particular context. The agreement indeed was made, it's in the record, that if you find that was the purpose of narrowing it down, if you find it that way, then these are the...
Okay.
Here.
But, so what do I make of your concession then?
I never considered it.
No, I haven't finished my sentence. What do I make of your concession then, in the first hearing and repeated here, that it is automatically defamatory to call somebody an apartheid era spy?
Okay. My lady, this is the point of
Are you withdrawing the concession?
No. It was
standing by.
It was not a concession. But let me
I think you need to look at the transcripts of the hearing and look at the media recordings of that hearing and tell me whether you made or didn't make a concession. By the way, it's not a ground of your appeal.
That's fine.
That my finding, my recording in my judgment, that it was conceded that if I find that this means apartheid era spy, that it is automatically In fact, I should have said more appropriately
Malady,
that it is unambiguously.
Malady,
Yeah.
might I make the final submission on this point?
No, before you go to your final submission, let's finish this point.
That's what I'm saying on this point.
Because on this point, I hear you say, you're now disputing that you made the concession. I really urge you to look at it over again. And when I revert in your reply, please clarify that it is violent. The second thing arising from it, let me accept for a moment your argument that if you call somebody an apartheid era spy, it will depend on the context. So let me ask you then, that if the context is that Mr. Zuma makes a statement, Mr. Hanekom is an apartheid era spy,
Yes.
and puts up no evidence, whatever the context, whether it's formal proceedings or in a social or social occasion, he makes that statement, puts up no evidence, and you're saying that it's okay to make that statement. Or if he republishes a tweet, Mr. Hanekom is an apartheid era spy, that's okay. Is that what you're saying?
My lady, can I? My submission is as follows, and I'll refer to it. We'll debate it, my lady, if the court permits.
You'll come back and answer my question.
I'll come to it, but I need to. It's part of this debate that
Right.
I'm making. That statement, indeed, it may well. Let's assume that in this context, it was considered that for that statement is per se defamatory. Let's accept that. I will deal with it in reply.
Albeit?
I will deal with it in reply. I will consult my team and the person who was arguing. That he says that may not always be defamatory outside this context. That's the submission we're making. So it may well be that in another context, evidence is not required. It may well be that in another context, quite frankly, the thing is not actionable.
It's not what?
It's not actionable as a defamatory action. And that's the submission we're making. And then can I refer you again to the case? Maybe my mistake was not to read the paragraph. In the case, paragraph 100 of our heads. The case of RM versus RB.
Yeah.
And the last sentence says, well, it goes on. It says, as set out earlier, well, it says, let me just, however, to grant an order sought in prayers 2.2 and 2.3 would be a drastic limitation and a restraint on the respondent's freedom of expression. A simplistic view of the relief sought may be met with an argument that the applicant is not seeking to curtail the legitimate and useful and lawful use of Facebook by the respondent. The applicant, it could be said, is merely seeking to restrain the respondent from making defamatory or derogatory statements concerning him. As set out earlier, this argument must fail because it is clear that not every defamatory statement made by the respondent about the applicant would be actionable.
No, I accept that as a general proposition, that may be true.
Correct.
But this is in the absence. What I'm still trying to connect is how can a statement which is admitted to be per se defamatory, you were an apartheid era spy, how can that be not defamatory? Whether it's actionable or not is a separate question, because I'm taking a very narrow aspect of your concession. You said it was defamatory, or your team, your leader, Stefania SC, conceded that it was per se defamatory. How does that make it not defamatory in another context. Who likes to be called an apartheid-era spy? Only an apartheid-era spy would like to be called an apartheid-era spy, I would imagine. Or you think somebody
I
else?
don't even think they would like to.
Not in this day and age. Exactly. You're confirming what I'm suggesting to you.
Well, the point is different, maybe. And it's either you take it or not.
Take the lead. Yeah.
No, I wouldn't say that, Melissa.
Okay.
The point is, assuming that concession is made, what I'm narrowing it to is the context of this case. But your order is far wider in our submission. It's wider, it may be in other contexts, which may or may not be defamatory in that context. It would be for that court.
Give me an example where Mr. Zuma can say, Hanekom is a star, an apartheid-era star, and it won't be defamatory.
Let's take where my leader says, well, if it's true.
Sorry?
He says if it's
If
true.
it's true.
But
But we didn't need to go down there because you didn't invite me to go down that path, which is something I'm still going to take up with you.
About
But
the
truth
truth.
and justification is another topic altogether. But yeah, show me a context where he can say that. Yes, it's true. That if there's justification, yeah, you can do that.
Well, Malaria, I'm trying to think of a context where it could happen. For example, it may be a case where he says something in a privileged occasion.
Privilege is a different matter.
Well, that's a different context.
Justification, privilege, privacy of his home or bathroom or wherever. That's not. We're talking about that. Defamation is a very technical concept. Publication, wrongfulness, and all of that come into it. So all those elements that must kick in when I talk about
And the
defamation.
differences, Malaria, and the differences.
Right.
Yeah. So
First the defamatory, then justification
Then
is the
justification.
defense. But we're not even in the realm of justification.
correct, Malaria. But what the order effectively does is to say, we will not even explore any justification. Once it's said something defamatory, it equals to a contempt order. That's what we interpret the order to say.
But you invited me to make that finding. Both of you did.
No, my lady, I think we may be talking at once. What we may well have said, and I'll check it in reply, I recall it in the answering affidavit or in the record, is that, and in your judgment, I beg your pardon, my lady, is that in the context of the circumstances we're dealing with, we can't give a general order getting out certain words in whatever context. We don't mind the context. You must just not say Hanekom is an enemy agent or Hanekom is an apartheid spy. My lady, you may not be convinced of that, but we submit that that is too drastic and far-reaching and unduly limits Mr. Zuma of his right. Now, my lady, now that you mentioned the issue of the truth of the statement, I'm not going to dwell on it. It also then depends on the reasonable reader interpretation. And we stand by our submission, my lady, that if you accept, well, one, Mr. Zuma does stand by the fact that Mr. Hanekom was an enemy agent, because the context is different to what he was referring to. That's why the debate was about calling political parties enemies and whether Mr. Hanekom was an agent of the EFF. That's where that debate happened. But it gets narrowed down by your finding, or what the party said, is that, well, if do you find that a reasonable reader will imply or would understand that Mr. Hanekom is an apartheid spy? Of course, Mr. Zuma is not making that case. He's not justifying that case. That's the submission. My lady, unless the court has any other questions?
Let's see what comes up after I hear Ms. Very standard.
Milady, I'm assuming you've read the heads of argument.
Yes.
So I'm not going to plod through the heads. With your leave, I think it might be most useful just to respond directly to what my learned friend brought up in the questions that came from the bench. Milady, clearly this case turns on what the sting of the statement is, what it means to the reasonable reader. And as we at the main hearing, both parties agreed up front that if the sting of the statement is that Mr. Hanekom was an apartheid agent, then Mr. Hanekom must win the case. And likewise, if the sting meant something else, then Mr. Hanekom must lose his case. That was how it started, and that is still the case now. So really the crisp question then for the court is, can the court say that there is, quote, a measure of certainty or, quote, a realistic chance that another court would find that the sting of the statement is not that Mr. Hanekom was an apartheid spy? That's really what this appeal is about, because everything else follows from that. And we submit that there is no measure of certainty and there's no realistic chance that another court would understand the words known enemy agent with reference to the Zondo Commission testimony to mean anything else but an apartheid-era spy. The first point, the first submission we make in supporting that proposition is that, as in the main hearing here today, there is a contradiction, a fundamental contradiction in what Mr. Zuma is saying. He is adamant that he never meant that Mr. Hanekom was an apartheid-era spy. That is not what he meant. Yet, he says, I still might want to say so. And that doesn't add up. He says, I might want to... So let me put it this way. On the one hand, he says, known enemy agent does not mean that he's an apartheid spy. But I might want to say in future that he's a known enemy agent. In other words, that he's an apartheid spy. He is saying both things at once. And, milady, they simply cancel each other out. And they underline the inescapable conclusion that known enemy agent does mean apartheid-era spy in this context. You can't have it both ways. If he says it doesn't mean that, I never meant that, there was absolutely no implication to that effect, then why does he want to say, but I still want to be able to say it? I still want to say known enemy agent / apartheid spy. That's what the last part of the argument was about. It's a thoroughgoing contradiction. That's our first submission in saying known enemy agent means apartheid spy. The second one is this, that when in argument, in these heads of argument and in oral argument, my learned friends want to say we didn't mean, known enemy agent didn't mean apartheid spy. They say, let me give you an example, paragraph 20 at the heads. of their heads. They say, Mr. Malema, the leader of the economic freedom fighters and a staunch political enemy of the respondent. So when they want to talk about political parties who are opponents, the furthest they go in their language is to say political enemies. My learned friend said political contenders. That is how the reasonable reader understands opponents in a constitutional democracy. They are political opponents, political contenders, even political enemies. But they are not agents. They're not known agents, enemy agents. There's a big difference between my political enemy and a known enemy agent. And my learned friend uses those two phrases sometimes as if they're the same. They're really not the same. And this court found that a reasonable South African or a reasonable person also wouldn't make that confusion. This interpretation that an enemy agent is someone who wants to remove him from office, I think Milady best dealt with that argument in the judgment, where it was pointed out that the majority of the ANC ultimately decided to remove Zuma from office. There's no way a reasonable person would then see the majority of the NEC of the ANC as enemy agents. And here Mr. Zuma, again, he conflates his own enemies with enemies of the ANC. Mr. Hanekom was part of a majority of the ANC that sought to remove and did remove him from office. Those are not enemy agents. They might be enemies of Mr. Zuma, but there's an unfortunate conflation of the two.
You refer to paragraph 20 and to the EFF as
Yes.
being in there, in this defense his argument, staunch political enemy of the respondent.
Yeah.
Who does he mean there?
The respondent being Mr. Zuma. He refers to...
Well, he's calling Derek Hanekom as the respondent. I don't understand. Maybe Mr. Stakan can clarify who he means by a respondent. But can we just stick to the terminology here that as per the original application?
Yes.
And if it's more convenient, just refer to the parties as Hanekom and Zuma.
So he says in the beginning of his heads, he sticks to the originals. So a staunch political enemy of the respondent is a staunch political enemy of Mr. Zuma.
That's how I read it.
Yes.
If I'm wrong, Mr.
Yes,
Stakan will
I'll tell you. But another example, if you look at paragraph 70 on page 21 of my learned friend's heads, he says it's most unreasonable to find that reference to political enemy is disallowed.
Did you say paragraph?
70 on page 21.
Yeah.
Now, in that, he refers to paragraph 60 of the judgment. Now, in 60 of the judgment, Milady was saying, in a constitutional democracy, we generally refer to political opponents. And with respect, I think this submission is taken out of context. This court did not prohibit or find that reference to political enemy is defamatory. And that's the point I'm making, that even in these heads and in argument, when they want to talk about what they mean, they say political enemy. They don't say known enemy agent. They carry different meanings. To the reasonable reader. No, it's well known that Mr. Zuma voted Mr. Mbeki. Nobody would think of him as a known enemy agent in that context. So, the context to which my learned friend is referring. My learned friend said that this court made a jump to the past in interpreting known enemy agent. And then in fact that word is used at paragraph 40 of the heads, that the court made a contextual jump by linking known enemy agent to the apartheid era. But it's not the court that made the link. It's Mr. Zuma who made the link.
So, he was responding to Mr. Hanekom's affidavit. When Mr. Hanekom goes into history, wasn't he entitled to do that?
Of course he was, my lady. I'm saying that my learned friend says that when the reasonable reader reads that tweet, known enemy agent, the reasonable reader would not think, 30 years back apartheid. The reasonable reader would think current issues being Mr. Hanekom was one of those people who sought to remove me and indeed remove me from office.
To sell out on me.
To sell out on me now. So he's saying the court made a jump that the reasonable reader wouldn't make to the past. But what he's wishing away is that Mr. Zuma said, like I testified at Zondo. Now, what was covered in the media, what caused a sensation with Mr. Zuma's long testimony was his calling out of certain people as apartheid spies, known enemy agents, in the apartheid days. The reasonable reader of a tweet does not then go and read days and days and days and days of testimony. But lady, I doubt there's anyone in the country, besides maybe a lawyer or two who's paid to do it, who would spend their time trawling through the record of the Zondo Commission. You'd have to be well paid or bats to do that. The reasonable person reads the media, the mainstream media, tweets, etc., etc. And the context there was Mr. Zuma's sensational accusations of people within the ANC, within the movement, decades within the movement, who he says had always been linked with foreign intelligence agencies and were spying on the ANC. So that was the context Mr. Zuma himself referred to. So it's not Milady who made a jump to the past. It's all there within that small tweet. He's a known enemy agent in the sense in which I testified.
So what might have been the situation if Mr. Zuma said in his answer, all this history, Mr. Hanekom, is irrelevant. I'm talking about now, and my ousting, for which you were a co-conspirator. And I'm not replying to anything you've said except now. How would that have played out?
Well, he'd still be in trouble for two reasons. Known enemy agent, just on itself, means spy, and known means of long standing. I have known for a long time. It has been known. It's not just this time. It's known that you're an enemy agent. Agent means somebody acting on behalf of an enemy. So just those three words, a reasonable reader doesn't think, so he meant agent of the EFF in this particular instance. It just doesn't mean that. And that's not getting to the fact that he then says, like I was testifying at Zondo. And then that just compounds it. Compounds it, where the testimony at Zondo was about apartheid-era spies. So together, it's a watertight reference to agents, spies, and apartheid-era spies, and known ones. So if one took that whole debate out about Mr. Hanekom's history and Mr. Zuma refuting that history, doesn't matter. In a way, my lady, the history at most goes to damages. That perhaps it's more egregious for somebody who sacrificed for so many years to be called an apartheid-era spy than it is for a person who didn't, even though both would be defamatory. It would go to damages, I would argue. So, my lady, our submission is it is absolutely improbable that an ordinary reader would read that statement and say, the link here is to removing Mr. Zuma from office as president. And that another court could not possibly find that language, with that reference to the Zondo Commission, was about removing Mr. Zuma as president of the country.
At the very least, it's possible, if one is generous, it's possible that somebody might come to that interpretation.
Is it, my lady?
It's one of several, but possible interpretations. And why not that it was a selling out of Zuma? A recent selling out.
Well, my lady, the various authorities that we quoted in our heads in the main case, and I think repeat some of them now, is our courts take into account the slipperiness of language, and that many statements have more than one meaning. The sting of the argument, the sting of the statement, is therefore the dominant meaning of the statement. It's not the only meaning of the statement, because there are precious few words in language that have one meaning. So the court is not asked to say it could only mean that he was an apartheid agent. The court is asked to find that is the dominant meaning, the most likely meaning for a reasonable reader. And I think we can safely say that interpreting that statement to mean selling out Mr. Zuma by removing him as president is not the dominant meaning. At best, it's a possible meaning with a few contortions along the way.
And if it was a possible meaning, what was Mr. Zuma's responsibility when he received the letter of demand?
Well, to clarify, he then should have said, Mr. Hanekom has the wrong end of the stick. I didn't mean that he was an apartheid spy. Actually, what I meant here was that he betrayed me. He sold me out when he met with Zuma to talk about voting to vote me out of Parliament.
Met with...
met with Malema, yeah. With not Malema, with the EFF. But he didn't. He refused. It was only when he came to court and had to make an affidavit that for the very first time he said, I didn't mean that he was an apartheid spy. He let that sit.
But he said more than that. Which takes me to the next. Sorry, are you done with your argument?
On that issue, yes, Madam.
Because what concerns me is that notwithstanding the narrow mandate both parties gave the court, notwithstanding the breadth of issues, and that you, helpfully both of you, narrowed it down for the court. So it was just an interpretive question. Then what do you make of my findings about false statements and justification?
That's exactly where I was going now.
Right.
So I want to start there with, it's paragraph 31 of my learned friend's heads of argument.
3-1.
3-1.
Yes.
Where my learned friend says, we submit that the court erred in demanding that the respondent provide evidence that the applicant was an apartheid spy. Now, my lady, this court was quite clear that this case is not about determining as a question of fact whether Mr. Hanekom was a spy or not. It was what the statement meant. The twist in logic here in these heads is this. If a litigant, if a defendant wants to raise the defense of truth and public interest, as Mr. Zuma did, then it is for the defendant, for the respondent to say why it's true. You can't raise the defense of truth and public interest and then say, but don't make me tell you that it's true. You can't have it both ways. So I can call somebody a rapist and a murderer, which is per se defamatory. But then then if I raise truth and public interest, I must show why it was reasonable for me to say that he was a rapist and a murderer.
In your opening remarks, the counsel suggested to me that if I were to find that it is defamatory, then the respondent will embark on a justification defense, or whatever defense it was. That was strictly not on my agenda, because if it was, then the question of evidence and all that might have kicked in.
Yes. So the court is correct that truth and public interest was initially raised as a defense to saying that Mr. Hanekom was an enemy agent in the sense that he conspired to vote me out of office. So I guess truth and public interest was raised to that end. But the confusion in these heads is that once this court has said, no, the sting of the statement is not that, it's something else. It's that he was an apartheid spy. In the main hearing, Sikhakhani SC said, I am not going to try and adduce facts to prove that he was an apartheid spy because I never said he was an apartheid spy. My learned friend comes today and says the court insisted that Mr. Zuma produce evidence, but the court never insisted that he produce evidence that Mr. Hanekom was an apartheid spy. It was never Mr. Zuma's defense in the first place. It never came up.
Well, it was one of Mr. Zuma's defenses. One was, I never said he was an apartheid spy.
Yes.
His other defense is that, yes, he is an apartheid spy. And that's a contradiction, isn't it? Yes, I did say that he was I believe that he is an apartheid spy. Because in his own affidavit.
Yes, it's true. He did say that. But I never understood his argument of truth and public interest to be saying, I'm giving you truth that he was an apartheid spy.
That was my understanding also. It just was in the affidavit.
Yes.
And whatever was in the affidavit was before me and raised as part of the argument.
Yes.
And it's still open as to who is an apartheid spy and who's a spy at all.
Yes.
For whoever. And who the wedge drivers are.
Yes.
That's also...
Yes. Today in these heads of argument, my learned friend says that paragraph must be interpreted metaphorically.
Which paragraph?
The one where he says, Mr. Zuma says in his affidavit that he was an apartheid spy.
And where does he say that in his heads of argument? Metaphorically.
Yeah.
That submission wasn't made to me when
No.
it was put up in the first place.
No, that is a new submission. Here, it's paragraph 47.
No, it can't be.
Paragraph 47 of the
47.
heads. Yeah, sorry, 47.
Conveyed as a metaphor, not as a fact. What is a metaphor? I don't understand it. Anyway.
Well, maybe my learned friend.
You'll tell me. This.
My lady, there's nowhere in the judgment where my lady says, I'm finding you guilty of defamation because you weren't able to prove to me as a question of fact that Mr. Hanekom was a spy. In fact, the judgment starts with Milady taking the opposite position, saying this is not a case about whether Mr. Hanekom was in fact an apartheid spy. That may be decided or may not by another forum on another day. But I'm not asking anybody to give me facts as to whether it's Mr. Hanekom was or wasn't a spy. And nobody did, either way. And my lady, that's the same argument as the false narrative argument, in this sense. That's on page 22 of the heads. At paragraph 76, my learned friend says, the court was not seized with determining the ANC political factions and moral standings of the parties. The court was not seized with determining whether the applicant's historical account is true or not. It was wrong for the court to make such a finding. Lady, the court did not make a finding. The court expressly did not make a finding. The court did not make a finding on the historical truth or otherwise. What the court was seized with was this. If it meant he was an apartheid spy, then is it defamatory? Yes, it's defamatory, and it's particularly defamatory in the light of the background that he put up in his affidavit.
The evidence is come across that there were two factions within the ANC.
Yes.
One who wanted Mr. Zuma in and one who wasn't. That's Mr. Zuma's version.
Yes.
Anyway,
Yes.
the second thing about the historical account, Mr. Zuma doesn't deny what Mr. Hanekom puts out to be his role in the imprimatur record and his conspiracy with Roland Hunter. He doesn't deny
No,
it.
he doesn't. So
he had
an opportunity
to do that.
and he didn't. The only thing he really questioned was Mr. Hanekom's exile. He said it was a staged exile. That was really the only. He didn't say why. He just said it was a staged exile, which is possibly in itself defamatory because, again, he didn't offer any evidence of that. But the rest of that history, the court correctly found it was uncontested. Mr. Zuma came to court saying, I'm not contesting that history. I'm not saying he was a spy. But I am. The lady, the defense of freedom of expression.
Where was that point, yes, about false narrative?
Yes. Page 22.
Is this application about false narrative even about my judgment?
No, my primary submission is the court never made a finding about narratives.
I understand that. I'm having difficulty in understanding the challenge to the judgment. For instance, if I say in my judgment it doesn't preclude the Mr. Zuma from testifying truthfully elsewhere, can it mean anything else?
No, my lady, the judgments, the order says, take this statement down and don't put up another statement like this one, right? But you are free to go out into the world, and particularly to the Zondo Commission, with any facts and evidence that you may have. What you are not free to do is to make a statement that's the equivalent of this one. It's perfectly clear, and courts have made it before. If the court merely ordered that you have to take down that statement, but did not order that you may not put up another one like it, then it's worthless in the applicant's hands. So you have to say, take that one down and don't replace it with one just like it. It's just a question of logic. But the court was then at pains to say, this doesn't stop Mr. Zuma from going out and talking about Mr. Hanekom as his political enemy, and if he comes up with the evidence, as an apartheid spy.
Well, I'm trying to understand if there's any ambiguity in that order, because if there is, then I can accept that somebody else might put up a different narrative that might be done in good faith and genuinely believing that it's open to a different interpretation.
You know, Melanie,
otherwise, it would not be
yeah.
open to another interpretation if it's not ambiguous.
Well, two answers, Melanie. The statement must, the order is always read in the context of the judgment. The judgment is clear that it's saying that it's calling Mr. Hanekom an apartheid spy without evidence. That is what's not allowed. Now, any defamation case says that you called so-and-so X, that is defamatory. It's not a gagging order to say you can't go out and call him X again. That's what these orders do. That's what the point of these things are. It's to say you can't say I'm corrupt and then go out and say I'm corrupt again. You can. Melanie, let me give you an example. In the case of Trevor Manuel versus the EFF, the judge interdicted the EFF from calling Mr. Manuel nepotistic and corrupt in the context of that judgment. So, for example, if in another context, in the old mutual context, it came out that he was corrupt, that court order could never have the reach because it's in the context of that judgment. So it can never be interpreted to say, if you ever call Mr. Manuel corrupt again in any context, you're in contempt of court. No reasonable person understands a court order to mean that. It's in the context of this judgment.
It doesn't set a precedent for that is binding on a commission.
Well,
least of all,
particularly,
commission would such like that.
Nor does it stop Mr. Zuma from doing what he's threatening to do, which to say, actually, I do have evidence. Because if he came out and said he actually was a spy and here's the evidence, that would not be contempt of court in terms of this judgment.
Yeah.
And I'd like to point out the difference between this order and the order in the case my learned friend cites, RM versus RB, that he cited, which was...
Paragraph 100, I think it said.
Sorry?
That was paragraph 100 of his book.
Yes, I think so, of his heads. And that was this division. It was a judgment of His Lordship Justice Chetty, where it was an ex-husband and wife dispute. And the ex-wife, after the son had been with the husband for the weekend, she put onto social media that her husband had mistreated, her ex-husband had mistreated the boy in some way or another, had been drunk in some way or another. And she asked he asked that statement be declared defamatory and taken down. And then he asked these were his words. He said, and to interdict her from publishing any further defamatory statements about me. Now, Judge Chetty said, I can't do that. I can't, this was about you being drunk and mistreating in this instance, which you didn't do. But I can't prohibit her from saying something about you in future on a different topic. Because
it might be defamatory, but justifiably so.
Correct. So And that is the point of distinction with this case. Mr. Hanekom did not ask you to stop Mr. Zuma from talking about him, to making defamatory comments about him. It's absolutely narrow. It says, you may not repeat what you've just done in the way you've just done it. That's the obvious meaning of the order. And if your judgment an order doesn't mean that, then there are many, many before you that also don't mean that, because this is the standard of what the courts do, to say, take away the offending one and don't replace it with another that is the same. But I'm not gagging you any further than that. And I'm particularly not gagging you in respect of the Zondo Commission, because Mr. Zuma had raised that as a particular issue. My submission is, if this is a gagging order, then practically every defamation order is a gagging order. It says you can't say that about the applicant. But again, Milady, at the risk of repeating myself, our submission is that this whole section on freedom of expression and this court stopping Mr. Zuma from saying Mr. Hanekom is an apartheid spy undermines what Mr. Zuma says the sting of the statement is. How can he emphatically say, I never sent that, I never meant that? It's not possible that that's what I meant, on the one hand, but then say, but you're gagging me from saying that which I swear I didn't say. It doesn't sit together. He's not an apartheid spy, but I want to say he's an apartheid spy. Melanie, just a point on all the law that is quoted. You know, there is the quote from, extensive quotation from the Citizen McBride case. It starts on page 89, paragraph 89, page 25, at the bottom.
Is that in your head?
Sorry, in my learned friends' heads. I'm just dwelling on them.
Paragraph, page 25.
Page 25, paragraph 89.
Mm-hmm.
And the heads purport to quote paragraphs 99 through to 102. But paragraph 99 leaves out the first sentence of the judgment. And I'd just like to read that first sentence. It says, it was also important that public debate about his fitness should, within the constitutional bounds protecting Mr. McBride's dignity and reputation, be untrammeled. Now, that is a critical sentence, because the ratio of this judgment is that a democracy like ours encourages political debate. It allows for rough and ugly political debate. And if you're a politician, you must be ready for that. You must, in colloquial terms, you must suck it up and not run to the courts. But there is a constitutional bound. Within the constitutional bounds protecting dignity. And Milady, I'm not suggesting that they left out that sentence intentionally, but they need to leave out that sentence in order to come home on what they want the law to say. The law says again and again with regard to political speech, it can do all sorts of things within bounds. Over the page, paragraph 100, the underlined bit. A constitutional boundary is the express provision in the Bill of Rights that freedom of expression does not extend to hate speech. Another is the legitimate protection afforded to every person's dignity, including their reputation. But so bounded, it is good for democracy. Not so bounded, it's not good for democracy, is the other way of reading that. So we agree that this is a political context, it's two politicians, it's not the same as two private parties. But it crossed the boundary of calling anybody an apartheid spy, if that's what it means, crosses the boundary. It's a gross violation of dignity. And in the context of a man who dedicated his life to the ANC and the struggle, it's an inexpressible violation of dignity. I have no more submissions.
Thank you. Is everybody all right to resist? Or do you need an adjournment?
My lady, my junior has asked me to do the reply.
Yes.
It's not usual that happens.
Yes,
but
Mr. Masuka.
yes, and I'll be very short.
Okay.
My lady, there's a question that appears to concern your ladyship relating to what may have been a concession made by in the previous hearing, and my learned friend I think has clarified it better because the concession was specific. It was that in the context of the role that Mr. Hanekom played within the apartheid struggle, it would be defamatory to call him an apartheid spy. It was not a concession of principle that calling someone per se defamatory, so calling someone an apartheid spy is per se defamatory, because that concession would be illogical. The way apartheid spies, it would actually mean that if you were to call, for example, Mr. Neil Barnett an apartheid spy, you would be susceptible to defamation, because the principle we are trying to establish is a principle that suggests that the words apartheid spy are per se defamatory. The concession was specific. It was within the context of Mr. Hanekom having said, and my little friend just said it at the end of her submission, that the egregious nature of being called a spy is measured against the role that Mr. Hanekom played in the apartheid struggle, which role distances him far from, in fact, it was an anti-apartheid spy role that he played.
Well, to put it differently, I think what you're saying, what both of you are saying, is that in the absence of any one of the many defenses that are available to defamation, that statement would be defamatory.
No, not necessarily, my lady, because I wouldn't argue that, because there was an apartheid system. That system was supported by an infrastructure of apartheid spies.
Yes.
And so to say that,
there'll be a justification for calling somebody an apartheid spy if they were a spy.
Yes, but
That's what I'm saying. If there's a defense.
Yes, I accept that, my lady. You can't call somebody who was not an apartheid spy an apartheid spy.
Unless you have good cause, justification, or one of the other defenses.
But we cannot elevate that to a principle of saying per se it's defamatory to call somebody an apartheid spy. Because the inquiry about whether or not is true, or it's said within the context of a political debate, or it's said within a context of
is it complimentary?
I wouldn't be complimentary to me, but I can assure you that
that is the context in which even Mr. Sakani said that Even apartheid spies don't want to be called apartheid.
No, but my lady, we're moving into dangerous territory. If we're going to hold people liable for making statements that are true, in the sense that they are saying something that...
I agree completely with you. The first step is to prove that a statement is defamatory. Then you go into the next phase. If you cannot justify it, that's where it says defamatory.
But lady, I don't know. I mean...
I hear what you're saying,
Yeah.
but you can't conflate the two. You don't get into the justification. There's no need for justification. There's no need for truth or anything if the statement is not defamatory.
Yes.
And if there's somebody who tells me that it is, to call somebody an apartheid spy is not defamatory, then it's mixing up the two tiers of the inquiry.
As long as it's understood that there is no legal principle that would make calling someone an apartheid spy per se defamatory.
That was the context in which the concession was made at the main hearing. And that is the context in which Mr. Skakane Jr. has also confirmed it.
Yes, so there was no concession of a principle. There was a concession specific to Mr. Hanekom. And that, as long as understood, then we're okay with that. And I think that's what...
There can't be any principle, because
So I'm right.
whether any statement is defamatory or not is contextual, and it is what choice of words are used in a particular context. It's not automatic. There's no principle about it. It's a question of fact from which
Yes.
you make an interpretation. There's no principle about it.
Yes. So I don't want to steal the thunder of my learned friend who, with commendable clarity and courage, made a good case for why your lordship should grant leave to appeal. There was just a few responses that I think are important, which arise from your lordship's interaction with the two of my colleagues.
Yes.
One of which is that there are a number of interpretations that are open, and your lordship, it seems to me that would accept that within the context of political debate, the statement made by former President Zuma in that tweet could mean that, Mr. Hanekom, you betrayed me by working with some people, by working with opposition political parties, and causing my removal from the party. Because, and that comes naturally from the fact that this was a political debate triggered by what Mr. Hanekom himself had said. Mr. Skakane has already argued that, and Mr. Malema's statement left on its own has implications for Mr. Hanekom's own dignity. Because Mr. Malema says, Hanekom gave us a list of ANC MPs who were going to vote with us in the vote of no confidence against Jacob Zuma. Today he calls us fascist. But Hanekom plotted with the EFF to bring down Jacob Zuma. The same goes with Solima Pai. So what essentially Mr. Zuma then says is that, you know what, I'm not surprised by this, because, of course, he's a known enemy agent. And in the context of what was going on at the time with the EFF and Mr. Hanekom's admitted role in mobilizing support against Mr. Zuma, that is how a reasonable reader of ordinary intelligence would read the to mean. It is confined to what Malema says was the role of Mr. Hanekom, and to what Mr. Zuma says. In the context, if you drag in the commission, it's been already argued. And at the commission, Mr. Zuma's big thing was the fact that the plot against him was to remove him from playing any political role.
So
That is his big thing.
Why did Mr. Zuma bother to reply to all the things that Mr. Hanekom said about the historical? Why did he not say, I'm not going to be bothered with this. My singular concern and connection.
No, because my lady,
is that tweet that arrived from.
Because I say, in your judgment, you do reflect that, my lady. But the problem with that approach, my lady, is this one. Mr. Hanekom takes a meaning that is obvious, adds apartheid spy to known agent, and says to Zuma,
So
to Mr.
what
Zuma,
meaning does he take as obvious?
he takes a meaning that is obvious,
What is
which
that
is
meaning?
which is that Mr. Hanekom is a known enemy agent.
You mean the literal meaning?
Yes, in the context of the political debate that was there, he never referred to him as an apartheid spy at the commission of inquiry when he referred to others as apartheid spies. At the commission of inquiry, if you recall, my lady, what former President Zuma said was to say that they were apartheid spies within the ANC. He went as far as mentioning their names, at least two of them.
No, coming back
He
to
never
that-
mentioned Mr. Hanekom.
no dispute about that. But his entire evidence was about apartheid spies.
No, not entire evidence. We were there, my lady. We actually know what he said
Yeah.
at that commission.
Well,
it was not.
that's what I asked. Is there
Yeah.
anything that he spoke about that was underlying? Anyway, I've asked that question before. But let's get back to this. My question still stands. Why did Mr. Zuma have to go into the detail of all the evidence about the commission and all of that? All the stuff that Mr. Hanekom raised about his history with the SADF and so forth. Why did he have to go into that and say, my story is very short. My story arises from Malema's tweet. And it ends there.
That's what
There's
he says.
No, he says that.
Yes.
But then why does he go in and gives me all this stuff about a metaphor that I'm hearing about now?
What metaphor is that?
Exactly. It's in your head.
No, that's our heads. That's what Mr. Zuma says as
Yeah,
evidence.
but it's your head. So
Yes,
you
no,
need
it's
to
fair
explain to
enough.
me, what do you mean?
What Mr. Zuma's case is set out in the answering affidavit. And my lady, why should a litigant or why should somebody be asked to answer a question on something he has not said? Why should Zuma engage lawyers to
What has
answer?
he not said?
No, because he never called Mr. Hanekom an apartheid spy. So Mr. Hanekom wants him to clarify whether he was calling him an apartheid spy
So,
when he never said it.
okay, let's just go back. Are you saying that Mr. Zuma is in a better position today by not clarifying when you received the demand,
No,
letter of demand?
no, my lady.
Why didn't he clarify, by the way?
What you also correctly reflected in the judgment is the fact that there is no love lost between the two of them.
So,
You say that in your judgment.
yeah.
So
That's
when Mr.
interesting.
Hanekom says to Mr. Zuma, tell me if you are saying that I'm an apartheid spy, in the context of what you've already said in your tweet, why should Mr. Zuma answer that in the first place?
So,
Is there a duty on Mr. Zuma to answer a letter of demand from Mr. Hanekom? A legal duty to answer a demand based on a false characterization of what Mr. Zuma had said in a tweet? There is no
what are the
duty.
consequences if you don't answer?
No,
the
what,
demand?
my lady, what are the legal consequences?
This action.
No, the action is something that Mr. Zuma can deal with. That is what Mr. Zuma is that he can deal with. But to say, Mr. Zuma, answer me on whether or not your tweet means that I am an apartheid spy, when the tweet doesn't say it, you're asking Mr. Zuma to engage lawyers and incur costs to answer something that on his
That's
own.
what's happened, isn't it?
No,
Because
but
if he's replied in another tweet,
my
say,
lady,
Mr. Hanekom, you got the wrong end of the stick. That's not what I mean.
he has explained it. It doesn't matter which forum he does.
No,
Whether
it
he-
does because it matters. One, it's a question of cost for the party. Two, it's a question of state costs by running a trial.
State costs.
It's a cost of the court. These are court services that the taxpayer
No, my lady,
pays for.
seriously, you can't
No,
say,
you
you
tell
can't
me
raise
that
that.
there's no consequences.
It-
There are consequences.
No, but those consequences are those are part and parcel of our rights.
I'm
The
not
right of
disputing
every
that.
litigant to come to court and to vindicate their rights.
No one is talking
Yeah, so
about
let's not.
denial of rights, Mr. Mr. Masuku. It's about consequences that you mentioned. What are the consequences? And practicalities. And what I'm raising is problem solving.
Yes, I understand that, but my lady I don't believe that you can elevate that to a defect of the nature
I'm
that.
not even talking about defects.
Yeah,
I'm talking about sensible problem solving, and in this context, political problem solving.
My lady, the problem is this. We assume that Mr. Hanekom would have welcomed.
I assume nothing.
No, but can I just make my submissions, my lady, without?
I'm
not really trying to. I'm just making a case for my client. I'm
Sure.
not trying to.
I understand.
I'm not trying to undermine the court or anything.
No.
All I'm saying is that if you look at what the manner in which you are suggesting should have been a reasonable approach, assumes that Mr. Hanekom, on receipt of a letter from Mr. Zuma saying, "I didn't mean what you say, I meant," he would have folded his hand, and that would have been all. In the context of the relationship Mr. Hanekom and Zuma had, it was open for Mr. Hanekom to even send his comrades to say, come on guys, can you ask this guy if he means that I was an apartheid spy? In the context of just the political relationship they had, he sent him a letter of demand. That means he went to lawyers. And he says, I don't want to talk to him. I actually want him to respond through lawyers and deal with the issue. Was already polluted from the beginning. So I understand your ladyship that if Mr. Hanekom in his affidavit would have said, now I've read your answering affidavit. I see what you mean by what you meant when you said that I'm a non-enemy agent. I accept that meaning. I take the matter no further than I have taken it. That would have been okay as well. Because as the Lordship says, that is another interpretation open in the context of the debate that was being said. Mr. Zuma responded, answered Mr. Hanekom's case, and basically said to Mr. Hanekom, all I said to you was that you are a non-enemy agent within the context of what Mr. Malema had said.
But
And
he
that was
actually calls him an apartheid agent.
Never called him an
Affidavit.
never, not once. Your Lordship can go to that affidavit. We've checked it. We have it here. We've checked it. There is not one word where Mr. Zuma positively says Mr. Hanekom is an apartheid spy. What he says is Mr. Hanekom tries to prevent me from calling him, should I want to call him in future, an apartheid spy. But he doesn't call him an apartheid
Where's
spy.
that paragraph in your heads of argument that you explained that away as a metaphor, which was never suggested to me when it was first raised in the main hearing? Paragraph 47. And you are referring to answering affidavit, page 31, paragraph 95.
So,
Let's get to it so that we're not under any misapprehension as to what it means.
right, in that answering affidavit, this is what the full answering affidavit said.
Sorry, can you give me a moment to get to it? Uh, 98.
It's not that paragraph.
It's paragraph 112.
Sorry, the reference is to page numbers. Let me just get to it. Just read it out for me in the meantime.
Paragraph 112 says, the statement that I posted about Hanekom says what it says. Hanekom worked with enemies of the ANC to advance their political goals against the ANC and to topple it from government. The statement that I published was therefore truthful, fair comment of Mr. Hanekom's conduct and protected under Section 16 of the Constitution. By assisting the political enemies with information to weaken the ANC and topple its leadership, Hanekom acted as an apartheid enemy agent.
So as an apartheid enemy agent is not equal to?
No. The ANC is actually, the history of the ANC, your leadership would know, it was replete with apartheid enemy agents coming into the ANC, pretending to be ANC, and then driving a wedge between its members. So if you take the political statement of known enemy agent and you put it within the context of what Malema had said about Mr. Hanekom, and then you take what Mr. Hanekom himself said about his role in the removal of Mr. Zuma.
So why
yes,
was that point not so? I beg your pardon, Angela.
So taken in that context, my lady, Mr. Zuma is not calling Mr. Hanekom an apartheid spy. He says he acted like an apartheid spy.
A simile, you mean?
Sorry?
It's a simile.
Yes.
But then, why am I hearing for the first time that it's a simile? Why did Mr. Skakana SC not mention that to me? When it was raised in the heads, applicant's heads.
It's in the affidavit, my lady. So it's in the affidavit. So
no, that argument was never raised, but it was in the applicant's heads. And I contemplated going straight to that point in my judgment and say, one-page judgment, Mr. Hanekom, Mr. Zuma has already called him on affidavit.
No, but that would have been incorrect because
it would have been.
Yes.
Now that you mention it,
yes.
Can you see how counsel's failure to
understand.
address a very vital point?
I understand that my lady, if it was not mentioned as clearly as it should have been, or not mentioned at all, then of course, at least it's in the affidavit. It's there in the affidavit.
Yes. Anything else?
Yes, my lady. My learned friend Skakana has dealt with the scope and the extent of the order, the order that Mr. Zuma is interdicted from publishing any statement that says that's probably clear, because if the statement says that Mr. Hanekom is an apartheid spy, that is clearly prohibited. Where the order says that says, but where the order is ambiguous, my lady, with respect, is where the order says or implies, because that is a judgment call to be made not by Mr. Zuma himself. Somebody else must make the judgment call on whether what Mr. Zuma has said implies that what he's saying is that Mr. Hanekom is an apartheid enemy agent. And so we say if the order had simply been interdicting Mr. Zuma from saying that Mr. Hanekom is an apartheid agent, that would have been clearer, because then you know the scope of your prohibition is defined. But right now we're talking implied, which can come in the form of Mr. Zuma saying in very deep Zulu something that read by somebody may come to imply that he is an enemy agent.
And then Mr. Zuma will say, no, that what I said doesn't draw a lead to that inference. No,
my lady, let's not make a mistake about Mr. Zuma. He says what he wants to say. He will say what he wants to say. You will make a judgment call on it. He is not going to come and we shouldn't prejudge Mr. Zuma and create an impression that there is a tendency on him to say something and mean another.
No,
that
you're
comment is
right.
Yes.
That when you say that somebody will have to interpret whether a statement in the future amounts to an inference that equates to the meaning of apartheid spy. Someone will have to interpret it. It's not for me, it's... if it doesn't equate to apartheid spy, that's the end of it. But if there's contempt proceedings and Mr. Hanekom says, no, this implies that you're repeating that I'm an apartheid spy, you're in violation of this court order, I'm citing you for contempt. The court hearing the contempt proceedings, and it won't necessarily be me, probably won't be me, will decide whether Mr. Hanekom is right in the interpretation he places, and there's a violation, or whether Mr. Zuma is right.
My lady, obviously, I worked on the presumption that your ladyship was still trying to appreciate our interpretation of why we think another court may look at this order and say, well, it's overbroad. We have to restrict it to what the case was about and what the sting of the statement was interpreted to mean. So, but obviously the order goes further than that, and your ladyship is correct that now we have to go, in order for this order to be implemented, firstly it muzzles Mr. Zuma's ability to understand the scope of his prohibition, because now when he says something, he must look back and say, okay, I've got to be careful here, because this may be taken to imply that I'm calling him a spy, or that I'm calling him an enemy agent. And I think that is what we say Section 16 would be offended.
Just show me that this discussion ensued because you say that there's a reference in my judgment to imply.
It's paragraph 5 of your order, my lady.
Let's look at that. Yeah.
And then, of course, I mean, as we said, enemy agent, my lady, doesn't equate apartheid spy. An enemy agent in the context of my learned friend referred to enemy agent within the trade union context, enemy agent in terms of the church itself, enemy agent in different sections of society does arise, where one party works against the interests of a larger group or a smaller group, and that group thinks that is working with the enemy agent.
Do you think that any reasonable reader would have thought this was a debate between the churches or within the church context?
Oh, my lady, I'm a Christian, and I know for the fact that that happens.
No, I'm talking about this. But we're in a particular context here. I'm only bound by the evidence and arguments in this case. And nobody has suggested to me that this is a debate in the context of some church.
No, my lady misunderstands me then. Because what I'm reading to your ladyship is paragraph 5 of the order, and I'm suggesting to your ladyship that banning Mr. Zuma from using enemy agent may well mean that when he appears in church and talks about enemy agents, this may apply to him. Because enemy agents doesn't equate to apartheid spy.
Okay, I hear what you're saying.
And then, of course, the imposition of this court order on the proceedings of the commission is in itself undesirable, with respect. Because what happens is this, that the commission now must have this judgment with it and this order. And all they need to say to Mr. Zuma is that you are under an order, Mr. Zuma, to testify truthfully.
Truthfully.
He takes an oath before he testifies within that environment. Takes an oath.
And who will determine whether it's truthful or not?
Well, in this case, the benefactor of the judgment determines.
No. Who will determine whether Mr. Zuma is testifying truthfully at
It's the chairperson of the commission, we thought.
Yes.
Yes, but now, my lady, is it desirable for this court to impose a judgment on the work of the commission?
No, his oath imposes that.
No, but the order here says that the interdict in the preceding paragraph does not bar the respondent from testifying truthfully.
Where's the restraint? I'm merely giving effect to his oath in the commission. And I'm putting it in there to make it clear that, or to avert this precise misreading and false narrative of my judgment.
No, but I mean, you refer to false narratives and in the judgment.
But paradoxically, it's now extending to my judgment.
No, but your judgment says it. Your judgment actually talks about false narratives.
Yes.
It finds that Mr. Zuma peddles false narratives. That's what your judgment says.
Yes.
So your lordship actually got involved in a debate about narratives. And now Mr. Zuma is going to appear in a commission of inquiry with a judgment that says, you mustn't peddle false narratives.
It's because he took the oath. He will take the oath again.
My lady, I mean, we would urge your ladyship to be open about the possibility that another court may see this order as an order that imposes an undesirable limitation on Mr. Zuma's freedom to testify before the Commission of Inquiry. Because what has happened here, my lady, is quite extraordinary. We have taken evidence of what Mr. Zuma says in a Commission of Inquiry. It's uncompleted evidence. And we're now talking about it in a court of law. Court of law makes that an assessment of what that evidence means. That evidence obviously is binding on the commission where it must be binding on the
What's
commission.
that?
No, my lady, court orders are binding.
Yes, but it's not binding
It's
on
164.
it's not binding in that commission. There's no precedent or hierarchy between this court and
My
that.
lady, then let's look at the problem you've created.
I am.
You give an interpretation. No, my lady, I think maybe I should not continue arguing because I'm making submissions. I get a sense that you are not patient with my arguments. It's okay to not like my arguments, but at least let me make them.
You're right. Continue.
So I'm saying your ladyship makes a determination that taking the evidence or that is made, the incompleted evidence that has been given in the Commission of Inquiry, that Chief Justice Zondo must still determine as to his veracity. It's been brought into this court, given an interpretation that it provides a sting for Mr. Hanekom to get an order interdicting Mr. Zuma from calling him an enemy agent. Let us assume that Mr. Deputy Chief Justice Zondo reaches a conclusion that is contrary to your ladyship's conclusion. We have a problem because the Commission of Inquiries does not sit as a court, and it would be unprecedented for a Commission of Inquiry to ignore what a court order says about the evidence that was before it. I can understand the other way around, because a court can ignore what a Commission of Inquiry says about the evidence. But I'm not sure that a Commission of Inquiry would be competent for a Commission of Inquiry to simply ignore what a court has said about the evidence that was laid before it.
Well, if the commission finds that the evidence that Mr. Zuma leads is truthful, Mr. Hanekom will be on the back foot.
No, but that's the problem. It can be avoided by this court not having regards to that evidence and allowing committee between two important processes to run in a potential conflict. It entangles Mr. Hanekom and Mr. Zuma in a never-ending conflict.
Would I ever be able to even talk about the commission if the tweet didn't talk about the commission?
No, but we have explained how the commission.
Must I just accept the explanation or deal with it because Mr. Hanekom has got a different interpretation? My question is, do I go into the commission at all if there's no mention of it in the tweet?
No, but my lady, that's why context is very important in these circumstances, because what we say when you look at the evidence given in the commission inquiry, we focus mainly on what he said about spies. It's sensational, but what he said about his the political onslaught against him, the fact that there were people within the party and outside the party who wanted him out of leadership roles. He says that many times in that evidence. And he doesn't necessarily say that all of them were party spies. He simply says that there was a concerted effort to make sure that he gets out of power. And Mr. Hanekom says, I played a role in that. And so a reasonable reader would say, well, how did you play a role in removing Zuma? Well, I went and did an alliance with the EFF and other political parties to get him out. But you are a member of the ANC, Mr. Hanekom. Yes, I am, but in this case, there was a greater good to remove Mr. Zuma. Would Mr. Zuma be entitled to have a view of Mr. Hanekom's role as a role that was consistent with that of a wage driver, let's put it that way? I think it's within that context that we say you could have interpreted that tweet with absolutely, in fact, as your leadership knows, part of what we say in our answering affidavit is that you have no regard to the evidence in the Zondo Commission. You have no regard to it because, firstly, that evidence is not complete. Secondly, Zuma will be cross-examined, no doubt, if people choose to cross-examine him. And thirdly, it's just committee between institutions that are playing an adjudicative function to let the commission run its course. And after the commission has completed its course and make certain findings relating to the evidence that Mr. Zuma has given, to then afford the court the opportunity to look at it and see whether the commission would have erred in relation to Mr. Hanekom's complaint.
If I should not have gone to the commission evidence at all, why did counsel at the main hearing not tell me so? And in fact, put it up in the affidavit, put it up in the argument. Commission evidence is out of bounds, don't deal with it.
My lady, we do raise that in our affidavit. We do say that the commission evidence is not admissible in these proceedings. You can't use the commission evidence, incomplete evidence, before the commission of inquiry to interpret what.
There's no striking out application.
No, we didn't do a striking out,
Exactly.
but we do make an argument. We do make that argument that evidence should not be considered for purpose of interpreting the tweet. We accept that what made it difficult was the fact that there was reference to the commission of inquiry.
That's the point.
But that difficulty could simply be obviated by giving, amongst the three, what your lordship accepted earlier on was that there was the potential interpretations other than the interpretation that was followed by Mr. Hanekom. By giving an interpretation that of the tweet that would fit the political context in which the tweets were given. And if that had been the approach of the court, then Mr. Hanekom would not have succeeded, because you would have upheld the political platform on which two political contestants were expressing their different views over, not even two, three, according to Mr. Hanekom, perhaps more, would have to say something about how this process of removing Mr. Zuma from political positions unfolded. My lady, those are our submissions. Unless your lordship has any questions, would ask that you grant us leave to appeal to the full bench of this division, or alternatively the Supreme Court of Appeal.
What's your preference?
My lady, I rather leave it up to your ladyship's discretion. It's a matter that we think can be dealt with by a full bench, but it's also a matter that raises issues that perhaps the Supreme Court of Appeal may have to deal with, arising tweets and the various legal issues that are raised there. But we certainly think that a full bench would be sufficient to deal with it.
Right, if that's all, are you done?
That is all, my lady.
Lady, may I just give you a citation?
Citation for what?
I referred to our court saying that the sting of a statement is the dominant impression, and that's the phrase used. The judgment is actually in our heads. It's the Independent Newspaper Holdings Limited versus Suleiman, a judgment of the SCA.
Suleiman is S-U-L-E?
S-U-L-I.
Yeah.
M-A-N.
Yeah.
And it's 2004, volume 3, All SA, 137, SCA, and the words "the dominant impression" are used at paragraph 77, which is the concurring judgment of Judge Nugent. Oh, sorry.
Is that it? Any authorities, do you want to refer me to Mrs. Kamsuku?
My lady, they are in our heads. We
You're
stand
happy
by
with
that.
that? Thank you very much. Judgment on Thursday at 11:30.